Melissa, what does it tell you that we are now talking about things that were put on the books in the 1800s?
I mean, this is a Supreme Court that believes in originalism, believes in interpreting the Constitution as it would have been understood in 1787. And to them, this is of no moment. If we're going to enforce laws, let's take it all the way back to the 19th century, to a time when women did not enjoy the rights as full citizens, when they were understood by law to be subsumed into their husbands and for all public purposes. Like, this is of no moment. So this is exactly what I expected when the Dobbs decision came out on June 24th. It was going to be chaotic. It has completely disrupted the landscape for reproductive care in the United States, and it's made almost every woman in the country a reproductive refugee to some degree.
Well, and to layer onto that, as you sort of alluded to there, it has made it an incredibly confusing moment for providers who now are trying to read the gray letter of a law around when a woman's life is in fact at risk. I have spoken to providers who've been on the phone with their legal teams asking them, am I allowed to provide the care that I as a doctor believe I'm supposed to be providing in this moment? I want to ask you, an abortion ban went into effect in Indiana last week, was then blocked by a judge this week. As you know, several other states have had this similar sort of tug of war with anti-abortion laws. How much do we need to be worried to this conversation that you and I are having about widespread confusion among doctors, among providers, among patients about what is legal and what is not? And how much of that, Melissa, was the point?
Well, all of it was the point. This confused and chaotic landscape is as effective a deterrent to providers and those seeking reproductive care as an outright ban. So just having this confusion where providers don't know where their medical judgment ends and the law begins is exactly the point. What we're seeing right now is basically the reproductive rights community doing the only thing that they can do right now, which is basically play defense and try and enjoin these laws to keep reproductive access flowing for as long as possible. You'll notice that the Indiana judge was a state court judge. They've stopped litigating these cases in federal court. They've turned to state courts and state constitutions. Some state constitutions actually protect more rights than the federal constitution does. But again, it really depends on the judges and how the judges view and interpret the understanding of those state rights and those state constitutional rights. So again, a very confused landscape. We're having something in Arizona where a judge is allowed a very restrictive ban to go into effect and doesn't find the state's constitutional provisions to be any impediment to that ban going into effect.